Can I have a third-party lawsuit in addition to my workers' compensation claim? Hi, my name is David R. Price Jr. and I'm a work injury lawyer in Greenville, South Carolina. I dedicate my practice to helping people who have been injured, and I want to share some valuable information with you. When you are injured on the job, you have a right under South Carolina's workers' compensation statutes to file a claim against your employer. Your employer is responsible for paying for all medical treatment that you require because of your injury, and to compensate you for the degree of disability to any body part that is injured in the accident. Your employer is liable for these benefits, regardless of whether your employer shares any blame in causing your injury. As a result of this no-fault structure, other damages that are available in an ordinary civil liability case are not available against the employer. These include damages for pain and suffering or loss of enjoyment of life. In some instances, however, there may be a claim against a third party who caused your injury, in addition to the workers' compensation claim available against the employer. The classic example is the person who's injured in a car accident while driving on the job. That person is not only entitled to file a workers' compensation claim against his employer, but he's entitled to pursue a third-party claim against the at-fault driver. Another classic example is the person who's injured on the assembly line due to some faulty piece of equipment. That person is not only entitled to file a workers' compensation claim against his employer, he's also entitled to a third-party claim against the manufacturer of the equipment. In fact, when you are injured by the actions of a third party and do file a workers' compensation claim, the workers' compensation statutes require you to pursue the third-party claim, or it gives the right to the employer to file this claim on your behalf. The employer is then entitled to reimbursement of benefits that he has paid for which you are compensated by the third party. If you pursue your third-party claim prior to pursuing your workers' compensation claim, and you collect from the third party before you file your workers' compensation claim, then you will be deemed to have elected your remedy, and you will be barred from bringing your workers' compensation claim. Although the employer will be entitled to reimbursement of some portion of monies you collect from a third party as a result of your injury, an injured person who collects benefits under a workers' compensation claim, as well as damages from a third-party claim, is still likely to recover more at the end of the day than if he pursues only his workers' compensation claim or only his third-party claim. For that reason, when you are injured at the job, it is important to consult with an experienced attorney who will recognize not only the available workers' compensation claim, but any third-party claim that may also result from your injury. My name is David R. Price Jr., and I handle these types of cases every day. If you've been injured on the job, regardless of whether or not that injury was caused by a third party, then I want to help you. Please call me at 864-271-2636 or visit my website at greenvillelegal.com. I'll give you the dedicated personal representation that you deserve.